Can a parole officer search a parolee's house to look for a gun without a search warrant? To find out, you have to read People versus Spirito, but it's 2 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Spirito. This is published by the New York Court of Appeals on May 21st of 2024. The issue in this case is whether it's constitutional for a parole officer to go into the home of a parolee and look for a weapon. To understand and appreciate the context of this case, the background that I think is helpful to understand is that there's a case from the New York Court of Appeals from 1977 called People versus Huntley, and it starts with the holding of that case, which is very important for this case. It states, "We hold that a parolee's constitutional right to be secure against unreasonable searches and seizures is not violated when his apartment is searched without a search warrant by his parole officer if the latter's conduct is rationally and reasonably related to the performance of his duty as a parole officer." So that's the case that is the precedent on the case of parolees and their right to privacy. It's not that they don't have a constitutional right to privacy. They do. But essentially an exception to the warrant requirement is a parole officer can search under those circumstances. What are the facts of this case? The facts are that in this particular case, the defendant is on parole. He agreed as one of the terms and conditions of his release onto parole not to own, possess, or purchase any firearm without the express permission of his parole officer. The defendant was given as part of when he was part of the Department of Corrections and Community Supervision, when he was an inmate, he was given the most severe mental health designation, which is designation OMH Level 1S, which indicates that there are serious concerns regarding his mental health. Okay. Shortly after he's released release onto parole, the defendant's mother contacts the parole office and says they saw a photograph of the defendant with a firearm, with a gun. And obviously the parole officer had not given him express permission to own, possess, or purchase any firearm. The defendant's parole officer then goes with a bunch of other officers to the defendant's home, which he shares with his mother, who had consented, incidentally, to them going into the house, and searched defendant's home and recovered an AR-15 style rifle, two 30-round extended magazines, clips, and with extra gun parts from the defendant's bedroom. He's then prosecuted for the felony gun possession crimes. He pleads guilty with a sentence of 4 years jail, 5 years post-release supervision. Before he pleads guilty, he has a suppression hearing. He moves to suppress based upon an unconstitutional search and seizure. The county court conducts a hearing and finds that it was valid. It was not an unconstitutional, rather, it was a constitutional search and seizure. So it's not suppressed. That's why the defendant pleads guilty. And ultimately, he then appeals his conviction to the Appellate Division 3rd Department. They affirm with one dissent. They say the trial judge was right. And it goes to the Court of Appeals. And in the Court of Appeals, it's only a 2-page decision, but they go back to Huntley. They repeat it and they say a search is okay if it's rationally and reasonably related to the performance of the parole officer's duty. And they say that the tip here was rationally and reasonably related to the performance of the parole officer's duty because parole officer has 2 duties. It's a dual duty. There's a duty to the public to keep them safe from the parolee, and there's a duty to the parolee to reintegrate them into society. So with respect to that duty to the public, especially in light of the defendant's mental health status, they find that it was valid with respect to the search, and they do not suppress it. Conviction is upheld, and that's the case of People versus Spirito. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.